Anti-discrimination laws have quirks that only apply to specific situations. To ensure you are on solid legal footing, listen to the questions that follow. For any you answer yes to, check out that section. If you answer no to all of them, jump to the end of this video. Does your employer have fewer than 20 employees? Did the discrimination happen over 180 days ago? Are you unsure whether you are an employee? Is the discrimination caused by a third-party employer? Are your employment complaints subject to mandatory arbitration? Does your employer have more than 20 employees? The Age Discrimination in Employment Act only applies to employers with 20 or more employees. Title VII and the Americans with Disabilities Act apply to employers with at least 15 employees. Some state and local laws have lower minimum numbers of employees. The Equal Pay Act does not set a minimum number of employees. An employer with fewer employees than the minimum required by state law may still be liable for workplace discrimination under the state constitution. In California, a woman was fired because of her pregnancy. Her employer had fewer than 5 employees, the minimum required under state law. The woman filed suit under the state constitution and won. You'll need a lawyer to sue for a violation under a state constitution. Employers need not work every hour of every day to be counted. The 15 or 20 employees need only work at least 20 weeks, either part-time or full-time, in the calendar year the discrimination occurred, or in the prior calendar year. What if your employer does not have enough employees to meet this minimum threshold? Even if there are not enough employees at your location, your employer might have more employees working at a second location. Alternatively, you might be able to find more employees if your employer is an integrated enterprise. An integrated enterprise is where two businesses' operations are so interconnected with each other that they actually comprise one business. The 4 questions that reveal whether a business is an integrated enterprise are the businesses interconnected operationally, like shared office space, equipment, storage space, payroll and benefit services, policy manuals, business licenses, managers, and employees? Do they share common management, like CEOs, directors, and officers who decide policy and oversee daily operations? Are the employment decisions centralized, like a central location that screens applicants, develops personnel policy, and makes employment decisions? Are company promotions and transfers between companies common? And lastly, are the companies jointly owned? Like a common owner, or does one company own a majority of the other company's stock? An affirmative answer to 3 of these questions is probably enough for 2 companies to be an integrated enterprise. The anti-discrimination laws do not mandate a minimum number of employees for state and local governments. Most courts agree that unions and employment agencies do not need a requisite number of employees to be covered, except a union must have at least 15 members under Title VII. Did the discrimination happen more than 180 days ago? Regardless of where you're employed, you have at least 180 days from the discriminatory act to file a charge of discrimination under both state and federal laws, which is likely what you want to do. The deadline to file a charge under federal law is often extended to 300 days when filing with the Equal Employment Opportunity Commission. I'll discuss this further in a video about filing with the EEOC. If you were discriminated against as part of a continuing pattern of discrimination, like ongoing harassment, of which some occurred more than 300 days ago, but at least one instance occurred within the last 300 days, you can file a charge about the entire pattern. Some state and local laws allow more than 300 days to file discrimination charges. Under the Equal Pay Act, you have 2 years to file a lawsuit. Filing a charge of discrimination with the EEOC does not extend this deadline. If you can prove the discrimination against you was intentional, you have 3 years to file suit. Are you unsure whether you're an employee? Independent contractors are not employees, they're self-employed. Individuals who are not independent or who are not contractors may be employees. If you cannot determine your own hours and method of work, must report to an office supplied by the employer, use the employer's equipment, and cannot work for multiple employers, you are probably not independent. If you do not have a contract and are paid on an hourly rate by an employer who withholds Social Security and taxes, you are probably not a contractor. Volunteers are not employees. If volunteering is required for employment or regularly leads to employment, then discrimination against a volunteer may be covered by the anti-discrimination laws. Partners, officers, and members of the board of directors may be employers rather than employees. Owners control all aspects of the business and share in the profits and losses of the business. Individuals who draw salaries and can be fired are probably employees. Is the discrimination caused by a third-party employer? A third-party employer violates the law when it discriminatorily interferes with the relationship between an employee and another employer. The third-party employer does need to meet the minimum threshold number of employees of the appropriate anti-discrimination law. The other employer does not. For a third-party employer to be liable, it must have some control over the relationship between an employee and employer. The amount of control needs to be enough to affect the start, the continuation, or the terms and conditions of the employee's employment. If the third-party employer made a discriminatory request of the employer, such as only referring employees of a particular sex or race, the employer would also be liable if it fulfilled the request. Are your employment complaints subject to mandatory arbitration? Mandatory arbitration requires that employees arbitrate employment complaints instead of filing in court. The provision can be part of an employment contract, a collective bargaining agreement, or any other agreement between an employer and employee. Mandatory arbitration clauses are unenforceable for sexual harassment. Most employees work at employers who require mandatory arbitration agreements as a condition of employment. I will discuss these agreements in greater detail in a future video. While technically they do not alter anti-discrimination laws nor change the strategies for opposing discrimination, in practice they greatly tilt the playing field to the advantage of employers. You made it to the end of part 1! Happy New Year! Now you know a little lingo, the elements of proof for your type of case, and you've dodged the legal loopholes. You're ready to learn how to prove your discrimination case. That's coming up next in part 2 of this series. Thanks for tuning in. I didn't forget.